Hi, this is Ryno of Ryno Law, PLLC. All of you have had questions regarding the Michigan governor's executive powers, and I have answers for you right after this. There's been quite an uproar in the state of Michigan lately regarding Governor Gretchen Whitmer's executive orders that she's been placing based on the COVID-19 pandemic. I get a lot of people asking me on Facebook what my opinion is of the legality of these orders. And the problem is it's very hard to give you a concrete answer because, quite frankly, until recently, there hasn't been a lot of litigation on this. And reasons why there hasn't been a lot of litigation probably is that no governor has used this as widely as Governor Gretchen Whitmer. It's probably only been used in a few natural disasters such as floods, different events like that where the governors had to use it. But the governor has issued well over 100 orders dealing with this, and litigation has been taking off. One of those cases was the Republican Party suing Governor Whitmer in the courts. Basically, the Republican legislature sued the governor, wanting to say that she exceeded her power, executive order power, based on the current statutes that allow it. The lower court did not find for the Republican legislature, and the Republicans took the unusual approach of asking the Michigan Supreme Court to hear the matter prior to the Michigan Court of Appeals hearing the case. In a 4-3 decision, the court held there was no reason that the Court of Appeals should not hear it first. They also did not order the Michigan Court of Appeals to fast-track this decision and to allow it to go through its regular, normal scheduling. The main thrust of the Republican legislature's argument is that the governor keeps extending the state of emergency more than the 28-day window allowed through the 1976 Emergency Management Act, which has right in the statute, and I'll provide links below, states right in the statute that there's a 28-day window, and then you have to get legislative approval, the governor does, to extend that emergency. However, the problem is when the legislature enacted the 1976 Emergency Management Act, they never invalidated the 1945 Emergency Powers of the Governor Act, which didn't put the time restriction on it. So the governor's been bootstrapping the 1945 provisions to help her out in her cause. As part of everything going on, local gym owners in the state of Michigan who feel that they've been slighted because gyms have not been allowed to open yet, bars and restaurants and other businesses have been able to open. The governor stated that gyms could not be open in an executive order. A federal district court judge out of Detroit granted an injunction against the governor's closing of gyms, primarily because the governor did not adequately explain during the hearing her somewhat unique treatment of indoor fitness facilities, relying on conclusory statements that gyms are dangerous. And she did cite some studies to that. And almost immediately, the state of Michigan appealed that judge's decision and asked that the preliminary injunction be reversed by a 3-panel Sixth Circuit Court of Appeals federal court. And the circuit court held that the injunction should not be held in place and that gyms should continue to close because of the fact that the plaintiffs would have to disprove all possible justifications for the governor's order, regardless whether those justifications actually motivated the governor's decision making. So even though she said basically gym's bad, everything else good, if there could be some justification out there for closing of a gym, that the governor's decision would stand. At this time, it does not appear, at least from what I can see, that the gyms have decided to file a motion with the Michigan Supreme Court. It's very rare that that would be granted. So what does this mean? Does this mean that the courts are just sleeping and letting the governor do whatever she wants to? Well, no. Actually, the Michigan Court of Claims, and the Court of Claims is a special court in the state of Michigan when you are suing the state of Michigan, actually held that the governor went beyond her powers by bootstrapping the Michigan Occupational Safety and Health Act and stating that an employer's violation, and this employer was a landscaping business, that an employer's violation would be under the MIOSHA Act, and that provided penalties, a $70,000 fine and 3 years in jail. The court held, nope, that's not correct. Under the Emergency Powers Government Act, the fine is $500 and 90 days in jail. That's established by MCL 750.504 because in the Emergency Powers Act, it does not, it states it's a misdemeanor, and when a statute is silent to the penalties for a misdemeanor, it's 90 days and or $500. It's interesting because the 1976 Act is $100 and 90 days. But because she keeps bootstrapping the 1945 Act, that is what the penalty is. So, what can I tell you about this? Right now, as it stands, you have to follow the governor's orders. There was recently a horrific abuse of power, in my belief, in Lincoln Park, Michigan, where a gym remained open. And this was after the Lincoln Park police told the gym owner the day before. This is my understanding and talking to some people that were involved. And the gym owner did not tell individuals that the Lincoln Park police told them that if they were open, they were going to come in. And instead of citing the gym owner for the violations, held over 40 individuals in this gym, brought them out one at a time, wrote them a $1,000 ticket, and I don't know where that $1,000 amount comes from either, and wrote them a $1,000 ticket and told them that they violated the government order and they're all set for court. So it puts you in a highly difficult area as an attorney when people are asking me, hey, so what do you think? What do you think about this? What do you think about HIPAA? What do you think about, if under the ADA, Americans with Disabilities Act, if I can't wear a mask? Well, here's the problem. That's all a defense, and it may be a defense for an appellate court to hear. Just like any other situation. For instance, I'm an attorney I don't necessarily believe the governor is doing things properly. However, I am subject to the law just like anybody else. And if I get a misdemeanor conviction, I have to notify the state bar, and I could lose my law license for having a misdemeanor conviction. It's definitely a real possibility. So it's hard for me to tell you not to follow the governor's order, especially since the courts have not tended to figure the statute out. The other issue comes with you're probably going to be a guinea pig as far as the situation, and it's going to cost you several $1,000s. So if you want to spend that kind of money and go through all sorts of appellate courts and all this other stuff and get a conviction, more power to you. But understand, this isn't something that's going to be handled at the district court. It's going to go beyond that. Now, saying that, could you have a jury trial at the district court level someday whenever they have jury trials? Because let me tell you, there's people out there that have been locked up almost 2 years on murder charges, and because of COVID-19, they have not had jury trials yet because those have been suspended in the state of Michigan. So someday maybe you would get to have a jury trial on this, and you could have, since it's a misdemeanor, 6 of your peers decide if you are guilty or not. Now, saying that, technically the law is valid. You're probably not going to get a lower court to say that the law is not valid. Saying that, you're basically going for jury nullification. You are hoping that one of those jurors say, hey, this is stupid, and there's no way that this should be a crime, and I refuse to convict this person. Now, that is something a juror is allowed to do. However, the defense attorney is not allowed to make a jury nullification argument. The court would definitely blow a gasket if you did that in closing argument. Now, it's something definitely a juror can do, but it's not something that you can argue for. So if you don't get jury nullification, welcome to the appellate process. So my advice to you, wear a mask, socially distance, do the things that are in the order until you're told otherwise. That's all I can do, folks, because I can't give you a sure answer. Like I said, everything else, the American with Disabilities Act, all that, that's a defense, and that might be something that you have to argue at an appellate level. It may not help you out at the district court level. Well, I wish I had better news for you on that, and I wish I could give you some better advice. However, based on the current situation and based on what I've been seeing in a lot of federal court decisions saying that local and state governments need the ability to protect its citizens during a pandemic, I really don't see this being overturned. What is the major problem here? The major problem is if you don't like the law, the legislature needs to change it. It's the legislature that gave the governor this power. The legislature could take that power away by getting rid of those statutes. That's your simple answer. So call your state legislator, write your state legislator, complain. That's your right. These people work for you. And that's all the courts are doing, are enforcing laws. And it's hard to say that a governor has gone beyond what they can legally do when a statute says that they can do it. So that's what I got there. As always, I appreciate you watching. Please, if you would, subscribe to my channel. It helps out my algorithm. You know, make sure you hit like, make sure that you comment on YouTube. And just don't comment on Facebook. If you could comment on YouTube, it does help the algorithm. If you hit the bell when you subscribe, that'll tell you when new content comes out. I'm Ryno of Ryno Law PLLC. If you're in trouble, get Ryno.